Good morning, everybody. At least for me, it's good morning. It's Friday, the 23rd of October, 2020, as you all know, in the middle of a pandemic. Some of you will be in Holland, some of you will be not, but to make you feel a bit at home, let's start with a picture of the view. In the evening, beautiful lit, but many of you will probably not see that for the coming months due to the very particular situation we are in at the moment. It's new for you, it's new for me, and it resulted in the choice of the VU to create lectures online. For me it's also new. I'm sitting at home, as you can see, and when you look behind me you see some pictures. One of them being my grandfather, who was a cattle trader and who inspired me a lot. But I did not turn out to be a cattle trader. I'm a lecturer and a consultant. I'm a lawyer. My name is Nico. My full name is Nico Jansen, and I'm a lawyer who combines a law degree, of course, with an MBA and a professional British qualification in marketing. That essentially represents what we are going to do. We are going to integrate law and business, because you need not be trained to be a lawyer, otherwise you would have chosen a different study. You are being prepared by the VU for a career, for positions in international business. From that perspective, we're going to look at the law, and we're going to focus on that part of the law which is of most interest to you, and that is business law. And within business law, we're going to emphasize the international dimensions of it. That does not make it easy, but that does make it rather challenging for you and for me. So let's see if it works if I by providing you with a text. There I am again. I hope it still works. But here's the textbook, and the textbook is called Law and Self-Regulation. Why not just law? Because law is, we will see, important for you as a manager. But in practice, equally important is self-regulation. What it is, we'll come to later in the course, but it basically is self-made rules. Self-made rules by companies, by industry organizations, and because they are self-made, you voluntarily submit yourself to it, and you will see a lot of it in advertising. That is for the moment. Now, if you go to the structure of chapter 1, which is the chapter we will look into in these slides and in this first week, you will see that what we just discussed briefly is reflected in the structure. We talk about law, section 1. We talk about managers and lawyers. We talk about legal system and business system. So we try to explore how the two link. And then I hope you see reflected this basic idea that we will start thinking from the perspective of strategic management. And we'll do that in a very simple way by stating that if you want to develop strategies, you start analyzing the external environment and you start analyzing the internal environment. Now, that will be explained, and we have to take into account section 1.4 that law is, just like language, not a universal thing. Law is a national thing. In order to understand law and countries' legal systems, you need a basic understanding of the legal traditions in the world, because they will help you in understanding the legal system of a country, and they will help you in understanding how the lawyers with which you cooperate think. What is their frame of reference, their frame of mind, from what kind of legal tradition will they communicate with you? So that's the structure of the chapter to understand. And of course we go deeper and deeper into things. We start broadly. But it was already said to you, we take corporate strategic planning as a basis. And why? Because we have a mission to accomplish, and that is we want to integrate law and business. So how does the textbook translate this basic idea? It will introduce you to legal and business concepts. You need this basic understanding, otherwise you cannot apply anything. We will introduce the 3 legal traditions. We will continuously try to find links between regulation and, as said, the important self-regulation and what you are preparing yourself for business. If we say you need to analyze the external environment and the internal environment, we need to give you a structure. So you will find structures in the book which will help you in analyzing, and you will be cooperating. So we will provide you with information on the types of legal services providers, how you can save costs, and some other dimensions which are part of that cooperation with services providers, in this case legal services providers. Let's start very simple. You will be running a business, and that business is subject to rules. That business is regulated. Now, if we start looking at regulation, we can create a kind of continuum to provide you with a basis for understanding. First of all, theoretically it is possible, and in some countries I also think it is the case in practice, that there is no regulation at all. Now, this is of course, from a business perspective, not an ideal situation, because you don't know whether your products are protected, you don't know whether your trademark is protected, you don't know whether you can get your money if the other party does not pay. So a situation of no regulation is, generally speaking, not the ideal situation for business. Now we have soft law, and soft law is basically a set of rules created by an important organization such as the United Nations or the European Union, which is not binding. But because it comes from an important organization, companies take it seriously. Then we have, as said, self-regulation. Your company, your industry makes rules and you submit yourself to it voluntarily. It can happen in practice that the legislator or the government starts cooperating with business in order to have something regulated. So state, legislator, government and business, they cooperate in creating rules, and that is reflected in the concept of co-regulation. They do it together. And finally, what we all consider to be a normal situation is that you have legislation, and the rules of legislation are in what we call acts or statutes. So in general, that means that something is written down somewhere in a book or an act, and the rules which we have to follow or which we can make use of can be retrieved by us, can be consulted by us, will be applied in court, and if necessary, the court will help you in enforcing the rules. Now, maybe self-regulation for the moment is a bit of a vague concept, but go to the website of a multinational. Well, my ethnocentrism leads me to Unilever, and on the website you will find, Unilever calls it a code of business principles. Others may call it a code of conduct. Some companies will call it an ethical statement. It can have all kinds of names, but what we can find on corporate websites of companies is rules of which they say, we respect these rules, we made these rules, we communicate these rules on our website, and that is how we will do our business. You will understand that that is, from a promotional perspective, a good thing, that as a company you show the world that you want to operate in a responsible manner, and that you inform everybody, and in business terms your stakeholders, about your own commitment to your own rules. Now, self-regulation is not only beneficial for companies from a promotional perspective, but it is also having benefits for consumers and for governments. Governments need to spend less time and less money on making rules when the companies make the rules themselves. Governments know, third point, that when the rules are made by companies, they have a legitimacy, as we call it. They have a respect, an acceptance by the business community, because the business community made the rules by themselves. That means that it has a better legitimacy, better acceptance, but it also means that they come into effect faster. I think you all will realize that legislative processes in parliaments, House of Commons, or in Senates, or in the second chamber as we call it, they are time consuming. So making rules by legislation can take a long time, and for reasons of efficiency and effectiveness, legitimacy, governments may be inclined to support regulation by an instrument which we refer to as self-regulation. Companies also see the advantages. If there is no legislation, it allows them to make their own rules. If companies cooperate on the rules, they create their own level playing field. They create rules which all of them have to abide to in an industry. As said, it is a promotional instrument. You can show the world, your stakeholders, that you are exactly doing what they expect from you. What does society expect from you? You write it down in your business principles. The good thing is also that you can create a body which among industries, enforces the rules. So if one industry thinks, hey, a competitor is not compliant, is not complying to the self-regulation, that company may file a complaint to an enforcement body, and the enforcement body will take a decision. It will say, yes, it was compliant, or say it was not compliant. And then the company, because it's all of a voluntary system, then the company will stop the practice. Now, it can also have advantages for consumers. The rules might be clearer in normal language instead of law, which usually is formulated difficultly. The processes to have the rules enforced might be easy. It can avoid the cost of having to go to court, because companies will generally create easy processes for consumers to complain, because the companies also have an interest in avoiding litigation. So for all parties, there are benefits in it. Can it be abused? Yes, of course it can be abused. What is the ideal situation? I don't know. This is what it is, and for you as a future business manager, for you to decide whether you want your company to develop, to have those business principles. And a good starting point for inspiration is soft law, because soft law expresses, for a big part, what society expects from you as a company. Now let's go to the international part, because this is the conceptual international business framework. This is a framework, and I'll hide myself for a bit so you can see the line below. This is a framework which we will be using for the lecture. This framework represents a potential future working situation for you. You might be managing EMEA, and EMEA is the abbreviation for Europe, Middle East and Africa. The blue countries are in there. You are managing countries, markets in 3 continents, around 115, 116 countries, and look at that, over 200 languages. That could be your future working situation. From here we're going to work, from here we're going to think. And to make it a bit more realistic, we have created a kind of a scene, the scene of the play of your future working environment, in which we incorporate the following elements. You have a nationality. Unfortunately, I cannot see you, I cannot speak with you, we cannot interact, because in the past I always loved to hear where IBA students came from. But okay, maybe I can hear it from some of you in the tutorial. But okay, in this scene, in this play, you have a nationality, you are married to an American man, girl, whatever you want. You have 2 children. What the nationality is, I don't know. Depends on where they're born, what the countries of the parents decide, etc., etc. Just to illustrate to you the complexity of the international world. You work in Paris. There at La Défense you have the international headquarters, and consider yourself to be a marketing manager, or if you want, consider yourself a CEO. Your company has subsidiaries in most EMEA countries, so it means they have an office, a company there. And what the company manufactures and sells, fill in by yourself, take a product which you liked and which within the course is ethically acceptable. And there are a couple of factories in Germany. Now, try to realize that situation as your future working environment. Phew, you would say, that's a pretty complicated situation. Yes, it is. And that is why companies are willing to pay large salaries, loads of money to people who are able to manage all these complexities, to manage their business properly. When we look at EMEA and we bring in what the focus of this course is, regulation, I think you immediately realize, hey, 116 countries, does that mean 116 legal systems? Yes and no, at least, because some countries have more legal systems. Take the UK, they have the law of England and Wales, they have Scottish law, they have Irish law, all different legal systems. And there might be some more countries like Nigeria, where you have Islamic law and common law. And what are the words I am now using? The words I'm now using are the words of the 3 big legal traditions. What you see here is a large part of the world which has a reddish color. It's not perfectly red, but it's a bit red. And you see here that those are civil law countries. You see that in the Netherlands, where we are now, the legal system is also a civil law system. But if we cross the pond to the UK, we see they are different, as they always are. They have a common law system, and we see that in the US, generally a big market for international companies. We also see that in Australia and some blue spots in other parts of the world. And then we have a substantial part of the world which has a legal system which is closely linked based on religion, and in this presentation it is referred to as Muslim law, but I will generally use the indication Islamic law. Now, in what sense do they then differ? The essence is the following. All the reddish countries have law books, they have statutes, they have written down the rules. The common law countries, they created a system, or I should say a legal system, originated because the prevailing philosophy in England, where the system originated, was that you should not give too much power to the state. if you give too much power to the state can abuse you, so the state should not make rules. Rules were made in courts by judges because the judges are the voice of the people and the people should make the rules and not the state. So the rules are in cases and not primarily in law books. If we go to Islamic law, then that is, if you're not from an Islamic country and you are from, simply said, the West, that is a challenge to understand, also for me, because here you have a very close link between religion and law. And the religious principles are incorporated in the law, and the law will not accept anything which goes against religious principles. So the division between law and state, as we will find in civil law and common law countries, might not be that perfect, although maybe perfect is not the right word, might not go so far as you may be used to. So we will try to understand what the existence of these three major legal families means for business. The first thing it means is that it is a reality, not to be neglected, to be accepted, and above all, to be respected. Nothing is strange. The starting point of thinking is that things are different. Now, I introduced it very briefly to you. And if we take the three traditions, we start by looking first at two things. Who makes the rules and what is in those states which have used these legal traditions, or in which these legal traditions are the basis of the legal system. That's probably better said. What is considered to be the function of rules? Well, the rule maker in common law is, as said, courts, judges. In civil law, we work with a legislator, a body in the state. Here in the Netherlands, the government and the parliament. They have the power, they have the authority to create rules, and we call that legislative power. In Islamic law, the rules are made by the Prophet, the creator of mankind, and they are written down in the Holy Book, and as we will later see, some other sources. In common law, the function of rules is to protect people against the state. In civil law, the function is that the relationships between people and between the state must be regulated with rules, and in Islamic law, law regulates the relationship with the Prophet, the relationship of the people with the Creator. Things might not be completely clear, might be a bit strange, but that's a given fact, and in the course more and more details will come when we focus on specific areas of law. We explore the differences a little bit more in detail by bringing in a legal concept, and the legal concept, at least this legal concept is a concept in civil law, and that legal concept is sources. Sources of law are the places where the rules can be found. Now, in civil law and in common law and in Islamic law, those sources have a hierarchy. Some sources are more important and therefore prevail over other sources. In civil law, the highest type of rules are the treaties, so the international contracts of countries. Then we have legislation, the rules as they are written down in law books. Then the decisions of courts in which they apply the rules. And we also can use customary law and general principles of law as so-called unwritten sources of law. In common law, the hierarchy differs. Case law is the main source, judges' decisions. Legislation comes after case law. Case law is more important. Treaties do not automatically prevail over national law, as generally is the case in civil law. And next to the common law, there's another legal system which is called the equity law system. And the equity law system is a supplementary type of law which can help out if applying common law in a case would lead to a decision which is basically unacceptable. Then a correction mechanism is available in the law of equity. In Islamic law, we have the Quran, we have sayings of the Prophet, we have a method to arrive at a decision by analogous, sorry, it's a bit of a difficult word, analogous reasoning. So religious scholars, when confronted with a question for which the answer cannot be found in the two preceding sources, will apply analogical reasoning. And finally, we have something which compares to equity law, and that is the istihsan, which can best be compared with what in civil law is called reasonableness. It's also a kind of a correction mechanism if a case, by applying the three preceding principles, would lead to an undesired outcome. You see, it's pretty different. It might at first, I think, be a bit overwhelming and a bit complicated, but just stay quiet, continue with the course, and you will gradually start. And of course, we try to do this by focusing on strategic planning, and at the same time try to make it a bit realistic by placing you in this EMEA function as a CEO or a marketing manager. Now, we start building further by starting again with this strategic management, and then at a certain level linking this strategic management with legal. We discovered, or at least we used, a very simple approach to strategic management, which is based on an internal and an external analysis. If you take that as a starting point for thinking and linking, you can simply say, yeah, if we are dealing with law, then we can come to a conclusion, and that conclusion is that from a strategic management, looking at law, we can identify two dimensions. Internally, there will be, generally in a company, a legal department. That legal department is the internal dimension, just like you have manufacturing, marketing, finance, accounting. You can also say a company has a legal function, often overlooked in the textbooks, but we have the opportunity to focus on it. And then we have the external environment, and the external environment is the external dimension. So, what can we conclude from here? The thinking you apply in strategic management and marketing is that an internal and an external analysis constitute a situation analysis. If we accept the fact that from the perspective of the law we also have an internal and an external environment, we can create a concept, and that concept is the legal situation analysis. Now, what does a situation analysis provide you with in strategic management or in marketing? It provides you with a basis, with a conceptual framework to arrive at strategies. So what we're going to do here is that we're going to say, look, we have a legal function. The legal function is the internal dimension of the company. We have an external environment. We have strategic management. Now, if we extend, make that strategic management a bit bigger than just the situation analysis we just discussed, we can make some nice conclusions about the legal function. Here in the situation analysis, we need to analyze legal and the external environment. What could legal do? Legal could help us with that, and the information they supply us with then becomes, potentially, if we're going to use it, strategic input. They can create, the legal department, information for us about what's happening in the outside world. Some of that information might be useful, and then it becomes, if we're going to use it in strategic management, strategic input. We can develop options and a choice of strategy in a strategic management process. If legal can help us with that, they can help us in creating and protecting value. Strategies have to be implemented and strategies have to be controlled, and that is an area in which legal could also help us. They can help us in risk management, specifically, of course, the legal risks, which lawyers understand better than average managers. And they can also help us in avoiding that we make mistakes. They can also help us in managing the reputation of the company. Now, that is a basic. You also know that the world is not ideal and that the world is full of threats. Now, I suppose you did a marketing course and you have a basic idea about what a threat is. Now, the beauty about looking at law from a business perspective is that we can use all kinds of usually freely available reports from consultancy companies to map the external environment. In those reports, there is usually a mix of business and legal information, so I cannot, when we talk about it, completely focus on just the legal dimensions, but there will be overlap between business information, political information, economic information, etc. We will focus on the legal dimensions, but accept the fact that there's sometimes a bit of overlap. But what I want to show to you is that you are having this task of getting information from the regulatory environment into your company. How you do it, that is management. We will come to that. One tip I want to give you for the moment, for two reasons, just to give you the tip and to show you something particularly, is to show interest in what consultancy companies are making available. This is a PricewaterhouseCoopers report, and it is an annual report. And the annual reports, which are freely available, they are the result of interviews with CEOs all over the world. And they try to identify what's happening and what the challenges are, what these CEOs see for the coming year. Now, you see here over-regulation, the perennial top threat. It's a bit difficultly stated, but what it says is what we will see on the next slide. If CEOs are asked, what do you see for the coming year as the biggest threat to your business, they, for years and years, come up with over-regulation as the number one, simply said, future pain in the ass. And why would this be? Very simple. If you manage an international company, see the EMEA map, then in all these countries the law changes. How on earth do you map that? How on earth do you make sure that you as a company are compliant? And how on earth do you realize that you can profit from changes? That's an enormous management challenge reflected in the first place for overregulation. The second problem for managers is that they are not lawyers. I'm not a doctor, I assume none of you will be a medical doctor. If we are being asked to examine the body of somebody, we can do it a little bit based on our fundamental biology knowledge, but we'll never fully understand the body. How can a manager understand the regulatory environment if you don't know what this regulatory environment consists of? You will be taught this in this course, but still keep in mind that a lot of managers educated in the past are not lawyers and have, see the top threads here, have great difficulty in mapping the developments in the external environment. There are more reports, and the reports indicate other types of threats. It will not be a surprise to you that thanks to Donald Trump and Boris Johnson, I was almost saying Boris Yeltsin, but it's Boris Johnson, that they are, certainly Donald Trump, an anti-globalist, and Boris Johnson is developing into that direction. They are moving away from the idea that globalization is favorably for everybody. They go for America first, and in the case of Boris Johnson, the UK first. That is a threat for you. Is that a legal threat? Not completely, but it is about rules, and those rules have to be created, and then we are in the legal area. How are these rules to protect countries created? And does the international legal system accept these kinds of protective measures? And in the case of Boris Johnson, what will be the situation towards the EU when the Brexit is completed? We don't know at the moment. We'll have to wait and see. And who has to deal with it? Managers, they have to prepare their organization for Brexit. Other reports, this one is from KPMG. They also try to map risks, and they come up with adapting your company to environmental requests. New technologies pop up. They also mention territorialism, cyber risks, and operational risks. So there's a lot of risks to be managed. We will not focus on all of them because the focus is on legal, but as said, there will from time to time be some overlap. And what does this manager say? A key focus for me is the evolving regulatory and policy landscape. It is a really difficult thing to get your arms around because at the end of the day, it changes. That's the reality. Continuously changing rules. That leads to a question. And business, the question is, who does it? Who analyzes? Are you going to do it? Will your legal department do it? Are you going to hire consultants? Will you make a mix out of it? That's all for you to decide freely as a manager. For the moment, this is an analysis structure, and the analysis structure consists of 6 S's. Here I'm back again. You can use it to do it yourself. You can use it as a briefing towards your legal department or towards a consultant. At least it provides you with a structure to get a grip on the analysis of the regulatory environment. What is the approach we take? The approach is you must find out what is relevant to you. Not all legal areas are relevant to all companies. Companies have specific interests. Pharmaceutical companies will be interested in changes in patent law. An electronics company will also be highly interested in changes in patent law, but also in trademark law. First thing you should do as a company is to decide which areas of law are of most interest to me, and I need to find out what developments there are in those areas. We talked about soft law as an expression of governments or the European Union or the United Nations, in which they say to companies, can you please? It doesn't say you must, but it says, can you please? And if you take yourself serious as a company, you will probably seriously consider the soft law and maybe implement it in. That's the next S, self-regulation, either by the company or by an industry organization. You are interested in how you're being scrutinized in the market. All kinds of industries have supervisory authorities, telecoms, financial markets, and you're interested in what direction they are heading. Are they going to be more strict on your industry or not? Are they planning to give higher penalties or not? It is something you are interested in, and you have to try and map it to draw conclusions from. You are interested in the courts, in the external environment. Are there any developments there? Specifically, are there new courts, new types of courts becoming available for companies? And of course, you are interested in services providers. You will have to cooperate with external parties. And just like you need to find the best possible advertising agency, you need to find the best possible legal or compliance consultancy, which, if needed, will help you. Providers, when we focus on legal and compliance, what compliance is comes later down in the presentation. If we focus on legal and compliance, the people who can help you are either in your company, so lawyers in company are called in-house counsels. You have, of course, the law firms. You also have specialized consultancies, and a lot of industry organizations provide legal support and legal information to their members. Now, you must, of course, also realize that when you are a company and you are managing that company, and that company finds out a development which could work out negatively for the company, that you may have to decide on lobbying. Lobbying means that you will try to influence a legislative process. For that type of activities, you also have services providers, you have public affairs consultancies. Your company may even have an in-house lobbyist. Industry organizations can help you in lobbying, and especially in Brussels, you will find law firms which are also providing lobbying services. Now, if we go to the legal department, we are now talking about the internal regulatory environment. And for analyzing that, we also have a very simple system. You could ask yourself, or you could ask a consultant, can you assess for me, you can also ask it internally, of course, how well is legal doing? How satisfied, how pleased are the managers in my company with the support they get from legal? You can talk to your accounting department or your financial manager, and you can say, what are the costs of legal? What are the salary costs and other overhead? You will learn in your finance module how to calculate that. Do we have a lot of bills from law firms or other consultancies? In other words, what are the total costs? We will look into compliance, and you can try to assess to what extent they manage compliance, adherence to rules properly. You can look at how good they are at corporate governance. In other words, how well do they support decision making at corporate level? And you can ask yourself the question, is the knowledge they have sufficient? This, of course, against the background of your strategy. A very simple example, you are planning to move into China. Do you have a lawyer on board who can support you with the legal dimensions of doing business in China. If not, you have a problem, and if you have a problem, it needs to be solved, so you might have to hire a Chinese lawyer. That is the way of thinking. So here you have a structure for analyzing the internal regulatory environment. I show you an example of a legal function, an example of a legal department. So what we will run through is, first of all, a bit more in detail one of the 6 C's. And that C is the C of contribution. So if you have this, what we just discussed as a background, we can look at a legal function at a legal department. Allow me to take a sip of my coffee. It is cold, but okay, it's something. What could the legal function offer you if we talk about their contribution to the business? Okay, they can help you in finding out what's happening, developments in the external environment. That is strategic input. We already said they can create value, but how can they create value? By ensuring that certain rights become available to you, like a copyright, like a patent. How can they protect value? They can protect value by protecting your rights, by protecting a patent, a copyright, by warding off infringements, by litigating in case of violations. The legal department can protect value. They can support you in risk management. For you as a manager, typical legal risks are a bit difficult to map, but legal can do it. Later on we will see how they can support you in reputation management. For the moment, let them draft some nice business principles or code of conduct. And of course, legal cannot spend endlessly on law firm advice or other consultants, so they can contribute to the business by reducing their costs. Here we have it. We're going to look at Calvin Klein. Calvin Klein is maybe a brand that appeals to you. And Calvin Klein was advertising for a lawyer. Now, they have a legal department, a European legal department, and that legal department delivers services to the entire company, and it has a boss, in business terms a functional manager. He's a senior vice president legal affairs, and he's also called a general counsel. The lawyer which heads the legal department in a big company often has the name of general counsel. The department has teams, and those teams reflect the areas of law which are relevant to a company. Corporate and commercial, so supporting the business, digital and data, intellectual property, which we will discuss in chapter 5, the protection function of law, brand protection, employment law, compliance and privacy, increasingly important, and legal operations, which links legal, IT and finance. Here we have it. We have a team of 24 legal professionals, and it's an international team, so they have varying nationalities, which means that you, having your nationality, having your culture, pending which national takes care of which area of law, you are confronted with the differences in nationalities and cultures. I need to take another sip of the coffee. My throat gets a bit sore. Now, they are having a legal counsel vacancy. You will work with a focus on corporate and commercial and or digital and data. Now, you will provide, that's what they want from the lawyer, practical, very important, no legal forgive me the word, bullshit, but practical information, corporate oriented, so business oriented, and no lingering, no long stories, no long reports, because the business is fast paced. So they want a lawyer who can cooperate quickly with them, who can really support this fast moving business. How can he support? He should review, draft and negotiate all kinds of agreements, including tech-related and license agreements. License agreement we will discuss as part of intellectual property, and you as a legal counsel will also interface, cooperate, help the business partners of Calvin Klein. Of course, the mentality should match with the business requirements and the mentality of business people. It should be a business partner, so no, forgive me the word, legal bullshitting, but a yes, we can mentality. Now, what should a lawyer bring on the table? Well, just quickly read it, but it's a bachelor or master's degree, at least fluency in English, preferably some more languages, and he should have a business mentality, and he should have a service mentality, because legal supports the business. And what can you expect? Well, I was pretty surprised when I read this, but apparently this is appealing to a younger generation of lawyers. They have a gym. Well, I found out that younger people are very fond of going to the gym. They have in-house physiotherapy. You can even get a massage on site. And they have a People's Place cafe restaurant located by the watery heart of Amsterdam. All very nice and attractive, I would say, prior to the pandemic, but at the moment it's not of much use. And they even offer you a chance to unwind with weekly social activities. I would consider that horrible, but okay. You are a different generation, you may like the drink on Friday afternoon. But as a whole, I think what they are offering is, in general, quite appealing to a younger generation. And that word was compliance. Increasingly, companies have legal managers and they have compliance managers. So we're going to introduce the compliance function, and let's look at what a compliance manager does. Generally speaking, I'll not read out what it says. Here is the situation the following. A compliance manager tries to map all rules which are relevant for the company and tries to communicate those rules into the company, tries to train people with respect to the new rules, tries to update all policies to the new rules, so that when the compliance manager gets a call from the director saying, John, you're the compliance manager, I just got a call from headquarters in the US. We're playing this game of you managing EMEA. John, I just got a call from the US asking us whether we are compliant. Can I say yes? Then the compliance manager must be able to ensure the CEO or the marketing manager that the company has implemented all applicable rules properly, so that the company is fully compliant and is not at risk of prosecution by supervision authorities or the risk of claims from competitors. So compliance simply comes down to, have I incorporated all applicable rules into my business properly? Now, also in this area you can consult reports for free, and you should realize that when you are a marketing manager or a CEO, you have the ultimate responsibility for compliance. So you should read into this and you should manage it. This is also a report from Reuters Thomson 2020 about the cost of compliance, because there is a general trend, and that trend is that companies need to spend, must spend, increasingly amounts of money on compliance. Now, in this report, this is reflected because the report introduces us to the 5 challenges which the board now face with respect to compliance. And it's more or less overlapping if we look at point 2 of what we said 30 minutes ago about this perennial threat which we saw in this PricewaterhouseCoopers report, the volume of regulatory change. That does not only make business complicated, but it also has a direct effect on compliance, because it makes compliance increasingly complicated. And that is also reflected in the first point, which states that boards increasingly see this problem of these rising compliance costs, because boards have an ultimate profit responsibility, and the more money you have to spend on compliance, very simply said, the less your profit is. And it also means that you, as a board member, a CEO, or a marketing manager, you must convince that the people who decide on your budgets that you need bigger budgets for compliance, because the world has become more risky, reputation has become much more important, you do not want to be prosecuted, you do not want to have claims from competitors, so you want to be fully compliant, but in order to be fully compliant you need people, and those people cost money. Also in this report we will find the top 3 of compliance challenges, and again here we see what we previously saw. The regulatory changes are the pain in the ass for managers. Constant change in rules, how do we make sure that we apply them? And point 3, a very difficult area for companies to manage, data privacy. Prosecution penalties are increasing all over the world, maybe not in the US, but at least in Europe. Respecting people's privacy is becoming a key issue for companies to manage, to be compliant with. Now, you also study human resource management, and if you want to hire someone, you need to know what knowledge that person must have in order to function properly in your organization. So what do managers say are the skills that HR should look for in their recruitment process? First of all, of course, knowledge about the rules which are relevant for the company you have, for the industry you are in. Specifically, compliance managers must be able to communicate very, very well, because they have to convince people to follow rules, to convince people not to break rules. They have to communicate in writing, updating policies, so communication skills are key. And of course, integrity, reliability, clarity, predictability, clear communication, and number 1, knowing what you're talking about. That's extremely important for compliance managers. I'll just go on. I'm going to integrate a bit. I hope you're all aware of the difficult situation you will be in when you are managing EMEA. We roughly said law's a national thing. Law changes in each and every country. We should not only look into law in the sense of legislation, but we should also look into soft law and self-regulation. And at least in these three areas, we must have a system which ensures that we get the right information delivered to us. That is reflected in this model, which very poshly is called a multi-level regulation matrix. But this is the situation you're facing. Hard law, soft law, self-regulation changes. It changes in country. It changes at a multinational level when countries cooperate. It changes at the level of the European Union, that's a supranational level. It changes at an international level, the WTO we can call the global level. But at all these levels, changes take place. Now I hope you understand this problem for managers. How on earth can we get this mapped? How on earth can we make sure that we get the right information? Because the world is a dangerous place for companies. If we focus on the threats from a legal perspective, then we can make two simple lists. A list of external legal risks and a list of internal legal risks. External, new rules may pop up. If we're not aware of it, we may violate them. Technology changes fastly. Legislation changes slowly. Some areas might not be regulated yet. So there are wide areas in which we may make mistakes. In the outside world, there are authorities which may prosecute us, impose a penalty on us. We may get litigated by a competitor, by a consumer association. That may also cost money, that may lead to negative publicity. And we might be present in countries where the judicial system is not as perfect as we would like it to be. Which means that if somebody steals a patent from us or uses our trademark without our consent, that it is impossible for us to protect our right in that country with that ineffective judicial system because, for example, the courts are corrupt. Those are typical legal risks. Internally, we may make a mistake by breaching a contract, and then we might have to pay a claim or a compensation. We may very easily break other companies or other people's rights, specifically in this digital age, where we might be using a picture without permission, using a design without permission, violate a patent, all kinds of things we could do wrong, which could lead to problems. A problem might be that the legal function does not have the competencies which it should have, and internally we should prevent the cost of legal from becoming too high by a very simple way would be setting a budget. Now, just to show you an example of what could happen, this is from December last year. It's about Ericsson. Ericsson is a Swedish company, but the United States has legislation, and that legislation is the Foreign Corrupt Practices Act, abbreviated FCPA, and the FCPA allows the United States to impose a penalty on a company which is linked to the US for any behavior anywhere in the world by which they bribe public officials. So the US, in this case, imposed a penalty, a fine on Ericsson, which is from Sweden, for their behavior in Egypt. And the total cost for Ericsson were 1 billion. So a mistake in Egypt by a multinational may cost a company a billion. So, I hope you sense the problem. Rules, 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 countries, 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 penalties, fines. Think about your career, no mistakes, and there we are again at the number one position of pain in the ass for managers, regulation. Well, to manage it, we can use a business framework, the SWOT analysis. I've made the idea of the SWOT analysis into a regulatory SWOT analysis. With this regulatory SWOT analysis, you have a conceptual framework from which regulatory strategies can be derived, and it comes down to a principle which you know. Internally, if you're good at something, and in this case, with respect to law regulation, you may build on it, use it to reach the company's objectives. If the firm's legal function has limitations, for example, as we said in this example, no knowledge about China, then that problem may prevent you, hinder you in realizing your corporate objectives. Opportunities may arrive, changes in legal systems may allow you, give you an opportunity to profit from it. And of course, the flip side of it is, the other side of it is, that legal changes may result in threats. Now, of course, what you need is information, information, information. So you need strategic input. On the one hand, you must create a system that information is delivered to you. On the other hand, I would advise you to scan the world for yourself also. We already introduced some nice reports, but there are more. This is the Doing Business report from the World Bank, in which they annually rank around 190 countries on a number of parameters. One of the parameters is enforcing contracts. That's pretty important for you as a business, because contracts are the basic tool to make money with. And we will show you in lecture 2 how the Netherlands scores on this. Now, then there are fantastic reports which build on this idea that countries can have rather complicated regulatory environments. So this one of the TMF group introduces us to rankings on the complexity of business. Here you have on the left side the most complicated companies to do business in, and here you have the least complicated companies to do business in. And well, Curacao, what that is, that's what we will discuss, that country, in the second lecture. But for the moment, the focus is on the United States and, proud to say so, the Netherlands, which are among the least complicated business environments, which is of course good for business, and that indicates that investing in these countries may be rewarding and with less hurdles and obstacles than in other countries. Now, what I would ask you to do is the following. As a manager, you need to be able to manage others, but above all, you need to be able to manage yourself. The game we're building on is this game, and the game is that you are working for this company, this EMEA company located in Paris, but in order to arrive in this position you had a job interview. That was on the previous slide, and here on this slide you have some examples of interview questions which were posed to you. I would say try to assess yourself and try to see whether you can answer these questions. It's a self-assessment, and you can judge for yourself whether you're able to do so, because if you do so, you might get the job. So, it was nice. It was difficult to start, but I think we got up and running. 1 hour 18. I think that is fairly well for today without a break. I'm going to call it a day. I really missed the international perspective by having students around from different countries and different nationalities. Nevertheless, it is what it is for the moment. I hope to see a substantial percentage of you in the tutorials, in which we will look in more detail in what we have just discussed. Because this is a pre-recorded lecture, there is no opportunity for questions. But please, if you have questions, try to bring them to the tutorial and we will look into it. In spite of the impersonal character, it was not unpleasant to do. I think we did something useful. I hope you agree with me. See you in the tutorial. Thanks a lot.